Hello everybody and welcome to History/Law Bite number 295, dated July 25th, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thanks for tuning in. Before I begin, I'd like to ask you to subscribe to my YouTube channel, Juarez Lee Shelton, M.A. Just click that little red subscribe button at the bottom and that little bell notification symbol next to it. Once you do so, you will receive notice when I post new and exciting material in history, law, political science, philosophy, and theology. Thanks in advance. This History/Law Bite is entitled Calder versus Bull, 3 U.S. 386, 1798. Okay? Calder versus Bull is another U.S. Supreme Court decision that was decided in the court's first 10 years of life. During that period, the court dealt with a lot of issues stemming from the American Revolution and on the basics of constitutional meaning in its most primitive form. Okay? In this particular case, the court examined the ex post facto clause for the first time ever. All right? And the holding, quite simply, all right, was that the ex post facto clause in Article 1, Section 10 of the Constitution, which contains powers denied to the states, applies only to criminal law matters, not civil ones. But you probably want to know a little more than that. Yeah, I agree. Of course you do. So we begin the same way the Supreme Court of the United States begins. All rise. The Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated. Mr. Chief Justice, may it please the court, presented here is Calder versus Bull. So, we going back to the 1790s, as I've mentioned, all right? So let's get into the facts. In this case, all right, we see that upon the death, all right, this case started as essentially a probate matter, all right? It says, upon the death of Mr. Norman Morrison of the state of Connecticut, Mr. and Mrs. Caleb Bull, you know, who are respondents here, were listed in Morrison's will as beneficiaries to his estate. All right. So a Connecticut probate court would, however, declare the will to be invalid, thus denying the Bulls inheritance rights. So the Bulls waited, for whatever reason known to man, more than a year and a half to appeal the decision, but they ran into a little problem. The problem was that under Connecticut law, an appeal had to be made within 18 months of the original ruling. Quite fair, right? That's a whole year and a half, all right? So if you got other stuff going on, you got plenty of time. However, they must have waited past that time. So, as such, the Bulls managed to persuade the Connecticut state legislature to amend the law, allowing the case to be successfully appealed. I don't know who these folks were, but they must have had some serious clout to persuade the state legislature to amend the law just for them. So, Petitioner Calder, all right, who was the initial inheritor of Morrison's estate, challenged this and appealed it to the Supreme Court of the United States in a timely manner, by the way. So, the issue presented to the court when the case was argued on February the 8th, 1798. They faced the simple question: by changing the law to allow an appeal after the deadline had expired, did the state of Connecticut violate Article 1, Section 10 of the Constitution and its provision on ex post facto laws? The opinion of the court, which was delivered on August the 8th, 1798, in a unanimous decision, said no. A unanimous decision in favor of respondent Bull was delivered by Justice Samuel Chase of Maryland, one of his most significant opinions written during his 15.5 years on the court. And I'll also add, just as another little history note, that Justice Chase was the only U.S. Supreme Court justice to ever be impeached in 1805. All right. Ultimately, he was acquitted because it was so politically motivated that it was just disgusting. All right. And Chase served the rest of his time on the court undisturbed. But anyway, Chase's opinion contained the following points. Number one, Connecticut's legislative enactment did not constitute an ex post facto law under Article 1, Section 10 of the United States Constitution. Number two, the court reasoned that the ex post facto clause was applicable only to criminal law matters, not civil law matters, and only criminal laws at that, which had one or more of the following effects, which I will list. First, every law that makes an action done before the passing of the law and which was innocent when done, criminal, and punishes such action. Second, every law that aggravates a crime, makes it greater than what it was when it was committed. Third, every law that changes the punishment and inflicts a greater punishment than the law annexed to the crime when it was committed. And fourth, every law that alters the legal rules of evidence and receives less or different testimony than the law required at the time of the commission of the offense in order to convict the offender. Number three, Chase reasoned that there was indeed a very sharp distinction between private rights and criminal rights. The ex post facto clause was never intended to protect private contractual rights of the people. Number four, while all ex post facto laws are retrospective, ladies and gentlemen, not all retrospective laws are ex post facto. Retrospective laws may and do legally exist outside of the criminal realm. And number five, in addressing other concerns presented, Chase held that the Supreme Court had no authority to determine the constitutionality of a state law against a state constitution. No person should be compelled to do what the law does not require, nor refrain from acts which the law permits. Okay, so I'll read a brief excerpt from the opinion. In my opinion, the true distinction is between ex post facto laws and retrospective laws. Every ex post facto law must necessarily be retrospective, but every retrospective law is not an ex post facto law. The former only are prohibited. Every law that takes away or impairs rights vested agreeably to existing laws is retrospective and is generally unjust and may be oppressive. And it is a good general rule that a law should have no retrospect. But there are cases in which laws may justly, and for the benefit of a community and also of individuals, relate to a time antecedent to their commencement as statutes of oblivion or of pardon. All right. So the judgment of the court here affirmed the lower court in Connecticut in their holding. So the legacy of this case is pretty long-lasting, okay? The Supreme Court nipped this one in the bud very early in the country's history, that ex post facto laws, at least in what is the Constitution is referring to, speak only to criminal law matters, not civil law ones. The ex post facto clause only prohibits criminally designed retroactive laws, not civil ones, okay, as indicated in Chase's opinion, okay? Chase made the clear distinction between ex post facto laws and laws that were simply retrospective, all right? And merely because a law was retrospective, as indicated in this case, did not necessarily mean that it was an ex post facto law that was prohibited by the Constitution. For the record, ex post facto laws are prohibited by the Constitution to the states from enacting in Article 1, Section 10, as well as the federal government in Article 1, Section 9, okay? And remember, for it to violate the Constitution, and either in Article 1, Section 9, prohibiting the federal government, or Article 1, Section 10, prohibiting the states. All right. Ex post facto laws speak only to criminal law actions, not civil law ones. Okay. And that is what this case made emphatically clear in Calder versus Bull. Okay. Once again, the ex post facto clause in Article 1, Section 10 of the U.S. Constitution applies only to criminal law matters. All right. Not civil ones. And the important distinction made between laws that were simply retrospective and ex post facto in nature is clearly defined in this case. All ex post facto laws are retrospective, but not all retrospective laws are ex post facto. All right. Calder versus Bull, ladies and gentlemen, 3 U.S. 386, 1798. If you have any questions or controversies, leave them down below, and I'll be happy to answer them. If you like this video, gain some knowledge or at least a little bit of knowledge from it, okay, drop me a like. That would be graciously appreciated. And if you've not done so at this point, please subscribe to my YouTube channel, Warres Lee Shelton, MA. All likes and all subscriptions matter. So I thank you once more so much for listening to this video. Hope you gained something out of it for whatever reason you did listen to it. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.